good to know.
And they have somewhat different takes on
We
it.
should get started.
I think we should get started. So let me welcome you all. Thank you very much for coming. My name is Tara Smith. I'm a philosophy professor, and I'll be the moderator. I'll say more about that in a minute. We gather, obviously, in turbulent times for talking. The nation, the world really right now, is having a series of roiling discussions about what's going on with Hamas and Israel. And alongside that, we're having satellite discussions of who should be free to say what about those issues, and who should be free to do what in reaction or on the basis of their views about those matters. Meanwhile, we've got escalating concerns about artificial intelligence. Every event has to mention artificial intelligence these days. You wouldn't be anybody if you didn't, so I had to get that in here. But we are having serious worries about what uses of artificial intelligence might do to the spread of misinformation, disinformation, particularly as a presidential election season looms. And all of this, of course, coming at a time when more people, vastly more people, have greater, easier access to greater numbers of audience members, of greater, they're also able to consume much more at speeds, at volumes that were just inconceivable not all that long ago. So I hope we have enough to talk about today. To try to make sense of some of this, of the meaning of free speech and the value of free speech, to talk with us about what's at stake in the debates about free speech, we have a distinguished panel. So let me say a little bit about each of our speakers this afternoon. Stephen Vladeck, on the far end, holds the Charles Allen Wright Chair in Federal Courts at the university here at UT at the School of Law. Vladeck is the author of the very recently released book, The Shadow Docket. It's already, it almost instantly became a New York Times bestseller. It got a lot of acclaim this summer when it came out. The Shadow Docket, How the Supreme Court Uses Stealth Rulings to Amass Power and Undermine the Republic. Vladeck has argued over a dozen cases before the U.S. Supreme Court, Texas Supreme Court, and lower civilian and military courts. He's received numerous awards for his influential scholarship, his prolific popular writing, his teaching, and his service to the legal profession. Vladeck is co-host, together with Professor Bobby Chesney, of the award-winning National Security Law podcast. He's CNN's Supreme Court analyst and co-author of Aspen Publishers' leading national security law and counterterrorism law casebooks. He also publishes One First, a popular weekly newsletter about the Supreme Court. Vladeck took his BA from Amherst College, summa cum laude with highest distinction in history and mathematics, then went on to receive his JD from Yale, where he was executive editor of Yale Law Journal and the student director of the Balancing Civil Liberties and National Security Post-9/11 Litigation Project. Gregory Salmieri is a senior scholar of philosophy in the Salem Center here at UT's Business School, where he holds the Brigham Fellowship for the Study of Objectivism and directs the center's program for objectivity in thought, action, and enterprise. Dr. Salmieri is a specialist in ancient philosophy, particularly the work of Aristotle, as well as the thought of Ayn Rand, with recent interests focusing mostly on issues in epistemology and political philosophy. Since earning his doctorate at the University of Pittsburgh, Dr. Salmieri has taught philosophy in different capacities at the University of North Carolina, Boston University, and Rutgers, and he joined UT, Salem Center here, in 2020. Salmieri is the author of numerous articles and popular lectures and co-editor of books Blackwell's Companion to Ayn Rand and Foundations of a Free Society. Finally, New York Law School Professor Emerita Nadine Strossen is past president, national president of the American Civil Liberties Union from 1991 to 2008. She is a senior fellow with FIRE, the Foundation for Individual Rights and Expression, and a leading expert and frequent speaker, media commentator on constitutional law and civil liberties. She has testified before Congress on numerous occasions, serves on advisory boards of the ACLU, Academic Freedom Alliance, Heterodox Academy, the National Coalition Against Censorship, and the University of Austin. The National Law Journal has named Strossen one of America's 100 Most Influential Lawyers. She is the author of a few books, including, not only, but including 2018, Hate, Why We Should Resist It with Free Speech, Not Censorship, and just published within the last few weeks, Free Speech, what everyone needs to know. And there's a lot to know that one can learn from the book, having recently read it. Another recent project, Strossen is host and project consultant for Free to Speak, a 3-hour documentary film series that's just been released on public television and can also be streamed on YouTube. And again, that's called Free to Speak, if you want to look that up, okay? Later this month, in just a few days, Strossen will receive the Judy Blume Lifetime Achievement Award from the National Coalition Against Censorship. The event today was co-organized by Greg Salmieri and myself, and the funding is coming from the Anthem Foundation and Voices for Liberty, which is dedicated to free speech, civil rights, and social progress. We're really grateful for their support. I also want to thank Sandra, if you're here, Sandra Garcia, who's an actual person, a human being right here on the ground, who's brought us to this nice venue and done lots behind the scenes. Thank you, Sandra. Format, I will serve as interviewer. I will kick us off by asking, in turn, each of our panelists 2 or 3 questions to start the conversation going, and others can chime in a little bit at that stage. Then I'll ask a few more general questions of anybody and everybody. Then after maybe 45, 50 minutes, we'll open it up to you guys, reserving just a few minutes at the end for some final questions. So let's hear. Why this book? Why this book now? What did you hope, or do you hope to accomplish? Tell us a little more of your thinking at this stage.
Thank you so much, Tara, and distinguished co-panelists and the rest of you for your interest in free speech. I will try to self-censor my answers. We've got a clock conveniently facing us because there's so much to discuss. But in a nutshell, after I wrote my book about hate speech, which, by the way, was driven by a concern that I think is still very animating to me. My entire adult career, and even starting during my student days, has been to advocate for human rights and civil liberties. And I still am wholeheartedly committed to all fundamental freedoms for all people. Starting in about 2015, we saw a rise of student activism on campus in support of human rights, sadly galvanized by some tragic incidents, starting with, I think, the murder of Michael Brown in Ferguson, Missouri. And while the tragedies of unjustified police killings were terrible, the silver lining to that terrible cloud was that we had a new generation of campus activists. I had been a student activist in the 1960s and 1970s, but in the interim, surveys showed that most students were not even interested in following political issues in the news, let alone getting involved themselves. So on the one hand, I was thrilled about the wave of student activism. On the other hand, I was very distressed about what clearly became a pattern of student activists for social justice becoming, at best, suspicious toward free speech and at worst, hostile toward it, including back at the University of Missouri itself. You might remember an incident where a student journalist was actually physically accosted by a journalism professor, as well as told that he was persona non grata by the student social justice activists. I continue, as somebody who could not be more passionately committed to these human rights issues, I continue to be convinced that freedom of speech is the absolutely essential engine for those causes, as well as every other cause, but I think in particular causes that involve advancing the equal dignity and full human rights and community participation of those who have traditionally been marginalized and disempowered. And clearly that conclusion had not been voiced in a sufficiently persuasive way to a young generation of activists. So I set about to try to make the case, hopefully with an open mind, and that's what I did in my 2018 book, which then set me on nonstop speaking on campuses and high schools and middle schools and community centers, not only all over this country, but all over the world. I've been giving about 200 public presentations per year, always as I asked of Tara in this situation, in the form of questions and answers, rather than my just being a talking head. I want to hear what people are interested in hearing and answer their questions and hopefully have them question my answers. So it's been a perpetual dialogue. And I discovered more and more clearly that people's hostility toward free speech 9 times out of 10 at least resulted from an ignorance about what free speech doctrines and principles actually are. That most of the critics of free speech were criticizing a distorted, caricatured version of free speech, and the more they knew about what its principles actually are, the history that gave rise to it, the negative experience under censorship, including censorship that is well-intended, such as laws against hate speech and disinformation, the more people knew about it, the more supportive they became of free speech. So I said to my husband, I ought to write Free Speech for Dummies. That will go a long way toward increasing support for free speech. And one of my friends, who's a literary agent, said, well, I think you can do a little bit better than that. Oxford University Press has this series, What Everyone Needs to Know, and it didn't have a book in the series about free speech yet, so that was a wonderful vacuum for me to step into. And as a coincidence, the format of the series is question and answer. So I was able basically to document in writing what I have been saying. And I sincerely mean what I say to all of my students, I say to all of the audiences, including the audience for the book. My goal is not only to, for you to be able to answer all of my questions, but also for you to question all of my answers. And you'll hear, I've already used the phrase, I continue to believe that. And I say that because I do continue to be open to re-examination, to new arguments, to new evidence, to new perspectives. So I look forward to continuing to learn from all of you, as I already did from your students this morning, Tara. Thank you.
Some of you guys. What was I going to say? So one thing is, it is in question and answer format, which, I mean, one virtue of that, just for the reader, is if you're just interested in one aspect, you're interested in libel, speech about, libelous speech, or interested in fraudulent speech, you can look up certain specific things and dip in and out as you're, so one needn't read it in one block. So I was going to ask you, and I don't know if you want to either elaborate more on this, I was going to ask you more about your thoughts of what's going on college campuses these days now. I mean, right now, these days has a special resonance in the last few weeks, but I mean, in general, and it sounds like, well, part of what even inspired you to want to write some of the both recent books was what was going on campuses and polls of young people less interested in free speech. But I know you're very involved with FIRE, which for a long time was the Foundation for Individual Rights in Education. They've since broadened a little bit to encompass expression more broadly. So if you'd like to elaborate a little bit more on your concerns about what's going on campuses with students, with faculty, with staff, et cetera, or a somewhat related question, but broader, I suppose, just as there have been concerns about, oh my goodness, young people don't value free speech anymore in the way they should. There's been a lot of expression in recent years about the ACLU not being what it used to be in terms of, in a very even-handed way, identifying your freedom of speech, regardless of where you stand on the ideological spectrum. There's been a lot of criticism that commitment has been wavering. So I'm interested in do you agree with that? Or why not? So.
I don't agree with that, but since I have only limited time for now, I think I'm going to answer your more general question. But if anybody wants to ask, because I'm very concerned about not depriving my co-panelists in the audience of freedom of speech. So the general question about campus, there are many, many facets to it. Again, for lack of time, I'm going to focus on just one, which was illustrated by the most recent of a series of annual surveys of the campus free speech climate, or lack of free speech climate, it would be more accurate, that has been conducted in the past 4 years by Fire and College Pulse. It is by far the most in-depth, granular examination of the state of free speech on campuses using various data as sources, including policies, administrative actions, looking at news sources, and then doing very detailed surveys of students about their perceptions. The data is all available in appendices, and Fire makes itself available to those who want to do a deep dive. But what the last survey showed, and it's consistent with the earlier ones, and this came out about 3 weeks ago, is that there is such enormous self-censorship on campus. Now, self-censorship can be a good thing, I mean, to the extent that we are always monitoring what we say in the goal of communicating as effectively and persuasively as possible. A superb advocate such as Steve Vladeck certainly is, making very careful decisions about how to present his arguments and his points to various audiences. If you're going to say something, by all means, try to say it in a way that's civil and respectful. So that kind of self-censorship or editing is just fine, and something that I try to instill in my students, the habits of communicating in a professionally appropriate way for a lawyer. But the kind of self-censorship that I'm talking about, and there was a very detailed definition in the survey that's consistent with this, is when you do not express a point of view or perspective, or even address a topic at all, for fear that what you say is going to be not only unpopular, but be viewed correctly or incorrectly as racist, sexist, homophobic, transphobic, reflecting some kind of insensitivity at best or discrimination at worst. And the campuses, even though they were ranked from 1 to 248, with my alma mater, Harvard, being number 248, way, way, way at the bottom. I didn't look up University of Texas, but it's irrelevant in the sense that from top to bottom, there was no difference in that at least 40% of students said that they are engaging in this type of self-censorship, not voicing perspectives and not addressing certain topics. In class, in conversations with professors, in extracurricular activities, and even in conversations with other students. And it wasn't because of fear that they would be punished by the professors or by the administration. It was for fear of peer pressure. Also distressing to me, and by the way, Fire said that the difference between the top-rated school for free speech and the bottom-rated, Harvard, the difference on this particular vector was negligible. So this is a pervasive, universal problem. If we had time, I'd be very interested to learn what the atmosphere, what the climate is here at UT. The Fire survey, College Pulse survey, also asked about some currently important hot-button issues and whether you on your campus can have a candid and frank discussion about this topic. And the most important topics, again, more than 40% of students across the board said no. The number one topic about which students said we cannot have a frank and candid discussion was abortion. Interestingly enough. Also way up there, immigration, police, not surprisingly, race and gender. So as somebody who cares passionately about voicing different perspectives, not only in terms of individual liberty, but also in terms of equality, that all voices and all perspectives should be equally aired, but also as an educator to aid you in your pursuit of truth, your exploration of your own ideas, but of what you think is good for society, and also in terms of democratic democratic discourse. How are we, the people, going to responsibly and effectively wield our sovereign power unless we can have free and frank discussions about these issues?
Thank you. So Greg, let me shift to you a little bit. And I'd like to really start exploring the whole idea of cancel culture. What is it? What is it? Is it a helpful term? Is it a confusing term? Should we perhaps instead just speak about shunning people or ostracizing people? Or is there something different there? Is it ever appropriate to cancel? I think there are a nest of issues we can talk about there, and I'm sure others will want to chime in on this at some point. I'd also like to talk about a culture of free speech or candid conversation more broadly. That is, there's the legality of speech, and then there's whatever the legalities, what kind of culture should we be fostering at a university? And so there's a lot. Why don't we just start with cancel culture, some of your thoughts about that as a concept and so on.
I mean, I think of cancel culture as a kind of ostracism or shunning. It came up, I think, the first time I heard it was in the context of Roseanne Barr being widely dismissed and fired and thought very ill of for, I think, some really gross comments she made. But it seemed to lead to a slate of people looking through people's back tweets and the idea that people gang up on them on the internet and so forth. And I think a lot of it was censorious and inappropriate and a culturally bad phenomenon. But for me, I'm very anxious to distinguish two things that often go under the heading of free speech, and I think it's really important to keep them separate. And one of them is speech that's free from force, free from the threat of being shot, imprisoned, beaten up, etc., if you say something that's out of line, and speech that is that you feel socially comfortable and safe from social consequences saying. So when we think about the students at college who are worried about should they bring up abortion, should they or race or whatever their view is, or Roseanne Barr, or people worrying about they might get fired from their jobs, they're not worried about being shot, jailed, or beaten up in most cases. There are cases where people are, but for saying certain things or expressing certain opinions. A lot of it is a worry about, will I get fired? Will I get boycotted? Will my name be spread around and my reputation, sullied and so forth, and in ways that aren't defamation, but just unflattering things about me being revealed. I think it's really important not to treat these as the same phenomenon, the same worry, the same alternative under the heading of free speech. There definitely is a lot of what I think is unjust and culturally bad shunning of opinions, of putting people down in overwrought ways for things they hold, in ways that is disruptive to the kinds of conversations that are helpful in reaching the truth, that are kind of essential to any functioning culture or country. But I also think the boycotting of people, the shunning of people, the choosing to fire people who say things that are abhorrent to you, the researching people and deciding whether you want to deal with them is a crucial and important right. I think it's part of, in fact, the right to free speech. I think speech and association are so associated. Do you support someone? If someone says something, you're in effect endorsing it by standing by them, and in some cases firing them or refusing to deal with them is an important exercise of your free speech right. So a lot of the activities that go under the heading of cancel culture, shunning, boycotting, and are sometimes seen as threats to free speech, I think are not only threats to free speech, but actually paradigm instances of it. The refusing to associate with people who say things that you find horrific, even if you're wrong in what you find horrific and you have too hair trigger for it, is an important exercise of this basic right to think for yourself, say what you think, and associate with the people who you want to. And when people exercise this right in ways that are unjust or immoral, I think it's very much like when people engage in hate speech. That is a kind of speech that I think is squarely within their right of free speech, but is immoral, wrong, unjust, unproductive, unhelpful. And what we should do as a culture is address it with free speech. Call them out for it, say that's unfair with you, unjust. And I think it's just, there's not really a great term for this other thing that I'm saying isn't free speech, but is a a culture of open discourse, a culture of civility, a culture that values dissent or heterodoxy. But I think it's important to find a term and separate them because I think they're just not the same thing. And when we talk about a culture of free speech, I think we can mean two things by that. One is the kind of culture that supports a right to free speech, that supports a politics in which people are free of force when they speak. Or we could mean a culture where people feel at ease saying whatever they feel like. And too often I think it means the latter, and that's a different thing. There are things you should be uncomfortable or embarrassed or ashamed to say. And part of what happens through our exercise of our right to free speech, through our right to debate, is that those things shift over time. The Overton window on things changes. Certain racist and sexist views that would have been perfectly acceptable by most people's lives in the past, and it might have been outrageous to challenge, are now outrageous to say, and that's good. That's part of how minority rights and civil rights has been advanced through free speech. So, but I think it's just very important to keep those things separate, and I don't see them separated enough in the free speech debate.
Can I ask a follow-up?
I don't have the terms for it
Just to
yet.
bring it to some of what's going on these days, you know, the law firm saying, we don't want to hire you if, you know, you've been participating in the pro-Hamas protest or something like that, right?
Or
So-
anti-Israel, and things like
Or
that,
anti, yeah, or, yeah.
depending where the lines are.
Right, right. But I mean, that is, what I want to just call attention to for a minute is, okay, people taking action. So it's not, and I mean, you said, I think pretty clearly, they have the right to do that. Okay, but do you think they should be doing that, or are there real danger, well, do you think they should be doing that? I mean, one thought is, you know, one view is, look, you have a moral obligation not to support certain things that you find egregiously immoral or something. Like, you should not support these people and so on. On the other hand, there are views, and I think this is your view, I think from some of what you've said and written in recent weeks, that it's a mistake to engage in that sort of action shunning and so on. So I guess, could I get,
Maybe,
where do
I
you
think
stand
all
on
three
that?
of us probably have views on these very complicated issues.
Sure, no, and I'd
yeah.
be interested in all, in briefly all of them.
I mean, should I start?
Sure, yeah, why don't you?
I think there's not a general answer to that. I think it depends entirely on who you are, what you're doing, and what kind of organization in particular you're involved with, that you're making decisions for. So I don't think there's a general principle that you shouldn't support things that you view as evil, right? But, and to say, you know, each side in a conflict thinks the other is committing genocide and equivalent to the Nazis. There are plenty of people who don't think either is or have some, but there are a lot of people who think Hamas is equivalent to the Nazis, and there are a lot of people who think Israel is a genocidal state and so forth. To say that you should hold hands with somebody or be a colleague in a law firm with somebody who thinks that, who you regard as endorsing Hitler, I think crazy. You can't be a moral person, and if you think that's your judgment of someone else, your attitude is, well, we should work together, talk together, regardless of the context. There has to be states where you say, conditions where you say, this is too much, I don't want to have anything to do with this, and you have to be free to do that. When you should do it, and what are wise and prudent judgments, I think depend a lot on the specific context. And it has to do with, like, is it a law firm? What kind of law firm? What kind of clients does it have? What are their policies? Is it a university? How large a university? What's the university's mission? Is it a university that aims to attract and educate a wide variety of people with different viewpoints? And if so, is the viewpoint you're wanting to exclude so well represented in the population that to exclude it, you're going to end up with a little niche? Or is it you're excluding, you know, some tiny view that's marginal in the first place? And I think you just can't answer this
In
as a
that
general
fact.
rule. And part of why I worry about calling this kind of issue free speech is the fact that I don't think this thing can be entered as a general rule, that it's so contextual, that it has to be balanced with so many other values and so many other factors. If you think of it as free speech, that makes you think free speech is an absolute. It's also something that has to be balanced and contextual and so forth. But I think that, what I think of as the right to free speech, that people can't be jailed, shot, beaten up, etc., for expressing opinions, is an absolute. And it's part of defending the absolutism of that that makes me really anxious to separate this issue from it.
Stephen, did you want to say something on this?
Um,
Many things on this,
Yes,
perhaps?
yes,
Yeah,
yeah.
I'm sure, that's fine.
I was going to make a joke that I have nothing to say. I actually find myself in the strange position of not yet having anything to disagree with. I think one of the complexities here is, even once you're talking about universities, there's an enormous distinction between public universities and private universities, which gets back to the line, right, that Craig's talking about. I guess for me, the real question here is ultimately, should the law be constraining these choices, right, or not? And when it comes to a law firm or any really private business, my answer is generally no, that there are actually serious dangers on the free speech side from government interventions that actually require
So
private.
by the note, just to make sure, no, the government shouldn't be restricting those law
Right, the
firms
government
from
should not be
doing it.
saying one way or the other, law firm, you
Right,
can or
right,
cannot do this,
yeah.
right? Like, to me, this is I mean, this is, again, I too am sort of uncomfortable calling that free speech, but it's some kind of choice, right? Cultural sort of liberty on the part of private businesses, at least insofar as we're not talking about, discrimination on prohibited grounds, right? We're not talking about, you can't come in here because you are of a particular race or sex or minority, like that, right? Where I think it gets tricky, and I use the now impending 5 Supreme Court social media cases to illustrate this, is that sort of line becomes elusive pretty quickly. So just think about sort of, I'm just going to use Twitter as an example. I think Twitter is actually a really bad example, but I'm going to generalize to Twitter. Right? Can Twitter, right, engage in content moderation? I think that the legal answer ought to be yes. The Texas legislature happens to disagree with me, right? And then the question is, well, can the state tell Twitter when and when not to engage in content moderation? But then the flip side, right? Can the federal government ask Twitter to engage in content moderation? Again, I think the answer is yes, as long as it's really a question and not a coercion, right? Like, to me, the line in Missouri versus Biden, hard to keep all of those cases straight, right, is it really coercive or not? So I think, to me, like, once you cross the line to a point where we actually think government should be able to tell private businesses which speech choices they can and cannot make, I think that's where it starts getting very, very slippery, versus the separate and equally challenging questions of when the government can do it directly.
These are such complicated issues, and I agree the nomenclature is a problem. There is a really critical distinction between government power to suppress speech and social powers. That said, for somebody who is concerned about a real lived experience of free speech, where everybody, in my ideal world, everybody would feel equally empowered and able to voice their views and to participate in civil discourse. This is one of the questions that I'm always getting about the government kind of free speech, government restrictions on free speech. And I think one of your students today sort of asked a question in that direction. But isn't it true that some people have meaningful free speech and other people don't? Isn't that something that concerns you? And it really does. So I am in the camp of never wanting government to impose these requirements, either on companies or on individuals. But through the efforts of education and persuasion and information, I would like all of us to be very conscious of steps that we can take to help our fellow citizens raise their voices and have the educational and technological and psychological resources to actually exercise free speech rights. And I also, looking at the reality, most people in this country, thank goodness, are not afraid of government punishing them or locking them up. But they are afraid of what their peers can do to them, and for all practical purposes, that has as potent a speech suppressive impact in this country as threat of government punishment has in other countries. In fact, a communications scholar named Cherian George, who teaches in Hong Kong and has studied communications issues around the world, wrote a book in which he said, ironically, in the United States, he finds much more speech suppression in the context of political campaigns and political debates, because of people's self-censorship, that he finds that to be a much more potent force than in countries, and he's specifically talking about hate speech, that we don't engage in it positively in many situations, as Greg says, not because we're afraid the government's going to punish us, but because of the social opprobrium, and that's even more suppressive of hate speech than in other countries where it's actually against the law. Now, where that becomes problematic is not the situation of somebody, hurling a racist epithet in somebody else's face. It's when, to say that you disagree with the policy of defund the police and then you're called a racist because you say that. We can all come up with examples of where there are public policy issues where voicing a certain issue makes you into some kind of an ist or some kind of an obe from people's perspectives, and that has a chilling impact. I have to make one other legal point in deference to Eugene Vladeck, who is an expert on free speech law at UCLA, and he's pointed out that there are actually, I was so surprised when I first read this, Steve, a couple of years ago, that there are a whole host of state and local anti-discrimination laws which do define as a protected class certain political beliefs. And there was a Stanford law professor who a few weeks ago wrote a very controversial Wall Street op-ed in which he said law firms should not hire any of these students who are making some of these pronouncements in the context of the Hamas-Israeli conflict. He said, you better take a look. He said, that's committing legal malpractice. You better take a look at the laws in the particular jurisdiction because it might actually be illegal to refuse to hire people on that basis.
Although I'll just say, I mean, I'm familiar with Eugene's work. I think part of those laws have usually, first of all, we live in Texas, we don't have laws like that. But second, those laws are usually about partisan affiliation. And so, saying someone who puts their name on a, I don't know, Hitler was right letter, right, that we might call that political. It's not going to run afoul of any of those laws.
Well, apparently some courts have interpreted it very broadly. So, but Eugene, to your question, should that be the law? He takes a very negative view that that's inconsistent with the freedom of association and other rights of the organizations.
Well, but not to derail us. I mean, there's a huge gap. I mean, the difference between the court's free speech jurisprudence and the court's free association jurisprudence is large.
And
I did
Sorry.
I wanted to address one or two questions just to Stephen before we go into more general. Okay, so we can come back to some of this. So Stephen, about your book, so the shadow docket, could you elaborate a little bit, because I'm sure a lot of students aren't familiar with what that refers to. I mean, it does refer to, you might say, the unspoken reasoning that, can absence accompany, I don't know, but I mean, it's rulings that the court makes that are pretty consequential. Is this guy, are we going to have a stay of execution here for somebody? Pretty consequential, but all sorts of decisions, not where they've heard a whole case and reasoned about it, as long as it takes them to, but decisions that are made without an explanation of reasoning. Could you maybe elaborate a little bit on the practice, and in particular, have any free speech related cases? Anyway, if you could elaborate.
Sure. I mean, I think I don't want to get too far off the theme of our conversation. I mean, the basic point of the book is that the Supreme Court actually does far more stuff through unsigned, unexplained orders than we appreciate, that we spend too much time talking about the 60-ish decisions the Supreme Court hands down after oral argument every year, and that's really only 1% of what the Supreme Court does.
1% on
Yes.
I mean, my God, that's, wow.
A lot of the other 99% is not of nationwide importance, but some of it is. And so just to take two very, very free speech related examples. So I mentioned the two sides of the Twitter coin. Those have both been the subject of emergency interventions from the Supreme Court in the last year. So last summer, the Texas's effort to basically limit social media companies from engaging in content moderation was blocked by a federal judge here in Austin. The Fifth Circuit, the Federal Appeals Court, unblocked it, and then the Supreme Court blocked it again. So that was a 5-4 ruling last May with no explanation. And part of why it was interesting that there was no explanation is because one of the 4 dissenters was actually Justice Elena Kagan, with Justices Alito, Thomas, and Gorsuch. So there's an interesting question of like, why did Kagan dissent? We don't know. No one except Alito wrote an opinion. But that's why the Texas law actually remains on hold. The Supreme Court's going to hear oral argument on these laws sometime in the spring and decide the case by June. And then just a couple of weeks ago, the flip side of the coin, a lawsuit by 2 red states and 5 individual plaintiffs challenging the Biden administration's allegedly censorship-driven contacts with social media companies, where a federal judge in Louisiana said, yes, I'm blocking all kinds of contact between the Biden administration and social media companies. The Fifth Circuit mostly let that ruling stay in place, and the Supreme Court put it on hold, again, over a dissent from Justice Alito. So, what's, I think, the overlap here is, first, here are examples where the court's unsigned, unexplained orders are directly impacting speech and access to speech. I mean, one of the things that the federal government had argued in the social media contacts case was that the district court's injunction itself was a prior restraint on speech, because the district court was telling executive branch officials, you may not reach out to Twitter and say this post should come down, right? But also just how speech in this context is actually effectuated, where the court is speaking without speaking. And one of the concerns, I think, when we talk about crossing the line from private cultural shunning, whatever, right, to government is, Siri's thinking about it too, right, is exactly that question of just when do we know when the government isn't speaking? And I think the court is not necessarily modeling the best behavior on that front.
I think all of these questions are so complicated, and when you made the point, Greg, about, there's no absolute, I think that's really true, and I think it would inform, it's true about the First Amendment law as well as the conversation about cancel culture, and I came to appreciate even more as a result of writing this book that there have been too many misleading and unfair binaries. Are you for free speech or are you a censorship proponent? I mean, does cancel culture exist or does it not exist? I think all of these questions, is it a good thing or is it a bad thing? You really have to engage in a multi-factor analysis. It's more nuanced and more complicated, but I think that's it's positive because it emphasizes that we all share certain goals. We all recognize that certain speech can be dangerous. I think we all recognize that government censorship can be dangerous. I think we all recognize that private sector actors can have a dangerous adverse impact. And the question is, that government should be free to speak, but not to coerce. These are not bright line distinctions. They're on a spectrum.
I mean, can I just say, I'm probably now going to get myself into trouble, but I would go further. Government should not just be free to speak. There are circumstances in which it is imperative for government to speak. I want the National Hurricane Center telling us when a hurricane is coming, and actually, able to tell us only what it wants to tell us and nothing that other people might want it, right? So government speech is complicated in this space because on the one hand, it has the risks of, police, prosecution, force, all the things that are not usually available to Twitter or Amazon or Walmart, right? On the other hand, we don't expect Twitter or Amazon or Walmart to, protect us from things.
Yeah, and I would go one further, and this will be a very controversial statement for a civil libertarian to make, but that I think in certain circumstances, government has a duty to punish expressive conduct that transgresses First Amendment limits. I mean, if people are engaging in a non-disruptive protest, that's completely protected speech, but at some point it crosses the line to become a disruptive protest, and at that point I think that the government, including a public university, has a responsibility to punish and discipline the disruptors in order to protect the free speech rights of the speakers and other audience members.
So can I say, I think, no one's up here saying less nuance, right? I also think, though, the other problem, and perhaps this is where talking about these issues and confronting these issues on a public university campus is, in some respects, unique. Because the speech issues are coming from multiple directions here, right? On the one hand, we have students who have free speech rights both in the cultural sense and in the constitutional sense, since we're a public university, right? We have faculty members who have free speech rights to at least some extent as a constitutional matter and definitely as a cultural matter. There are academic freedom pieces of this, right? And then there's also the fact that as government employees, we are sometimes subject to more aggressive, like I can't necessarily, I can't publicly campaign. I can't have campaign posters all over my office for political candidates, right? I mean, so, this is, I think, the tricky part of how this all meshes, right? Which is that speech is not unidirectional. And it's not right? It's
exactly.
going in different vectors at all times.
And every time that somebody says something, it can have a speech suppressive impact on somebody else. So this is not just true with so-called cancellation attempts, but that, after all, is the rationale for suppressing hate speech, which I very much understand. It's not just free speech is on both sides of the equation, right? I think a very plausible argument can be made that if you allow somebody to engage in hate speech, that's going to have a speech suppressive impact on the individual or group that's targeted by the hate speech. So it's all, we lawyers use the phrase a delicate balance.
Yes. I'd like to come out against nuance and balance,
Yay.
actually. Although it's more an issue of where the nuance and balance goes. So, or where the nuance goes and whether you should balance. So there's a way in which you can say everything is continuous, everything is messy, everything fades into one another, and so we can't say anything absolutely. We can't say, for example, free speech is good absolutely, or there should be an absolute prohibition on this or that thing. I think a lot of the work in defining our concepts well, concepts that are going to be used in law, concepts that are going to be used in statements of morality, is defining things in such a way that we can then make absolute statements. So I think if we think about what free speech is, we should be able to say we have an absolute right to it, and that you can't defame somebody or you can't make true threats or whatever isn't an exception to the right to free speech. The problem is that's not free speech in the first place. It's a different kind of, and the question is, there's a lot of nuance in how you draw those lines and make those distinctions, but I think it matters to make them, and I think a lot of them have been made in free speech jurisprudence on the thing you say about true threats isn't that, well,
So, I
they're,
mean, I think,
go
one way
ahead.
maybe of taking what you're saying is to say, earlier you were saying, when I was asking the question about, law firms, let's say, canceling offers to would-be,
Right, but the law firm's clients have speech rights as well,
Right.
right?
Yeah. But, I mean, you were talking about, so much depends on the context, what kind of law firm, but there's it's one thing to say, a lot about the context matters. It's another thing to say that it's all context. And
Yes.
there's no
Yes,
principle,
yes.
and it sounds like what
Yes.
you're saying is, look, there've got to be through lines and principles, and then how they apply to this kind of case or that kind of
Exactly.
case depends on a lot of the particulars, but there's a
Yes.
right, I mean, if I understand you
Yes.
correctly,
And
Greg.
one of the
something like
principles
that.
I think is important is to separate out cases where what we're concerned about is somebody being forced, either by the government, jailing them, whatever, or by them being physically assaulted, attacked, shot, maybe with the government looking the way, as happened so much in the case of the abolition movement and so forth. But where that's the thing that we're talking about. And
But
and
even-
when we're talking about someone might lose their job, someone might, which is a real, thing and a problem, but it's a very different kind of case. And I think that's something that you can draw a bright line between. And the one of them, I think you can handle in a much more absolute way than the other, which I think is much more contextual.
Well, now, I'm not quite sure if I understand your distinction, Greg. If it's a distinction between government having access to a certain kind of power that private sector actors don't have, or if you're talking about some kind of conduct that either government or the private sector can engage in that, as a practical matter, deprives the target of free choice. Because I think for many people, being faced with losing a job as a practical matter has at least as much coercive impact on them as fear that they might be subject to a fine from the government.
I think there's a real difference in how you can deal with those types of misfortunes. So I think it's not just government versus private actors. because I think a private actor, if they, for example, break into a magazine and shoot the cartoonists there, right, is engaging in for the same kind of thing the government would do if it imprisoned cartoonists. It's just I don't think we need special laws against private actors doing that because we already have laws against shooting people. But it is true that some people are more concerned, and maybe rightly more concerned, about losing their job than about getting a fine, or about being ostracized than about being beaten up. But the remedies, if you're somebody who's worried about losing your job or worried about being ostracized, I think are quite different than the remedies you can. The way to solve that problem, if you have it, is to find other jobs, to find coalitions of people who support you, to find et cetera, which is different than if you're in jail or if you're fine. So I think it's not that one is worse than the other. It's that there are different types of things than the other. Hate speech is often worse than minor assaults. Like if you pick someone's pocket, I think you're often treating them less unjustly than if you yell
Stand
a
in their
racial
face and shout at them.
or just yell a racial epithet at them in a way that I think is free speech. But the issue isn't that violations of free speech are always morally worse or more impactful. It's they're a certain kind of wrong. And I think they have a certain kind of way of dealing with them that's different from others.
I think the other complicating factor in the employment context specifically is that I suspect everyone in this room can find some circumstance in which an employee is absolutely, subject to, should be terminated and should be subject to termination for things that they say. So for example, right, divulging trade secrets of the company you work for is speech. I suspect no one's going to stand on the notion that that shouldn't be a fireable offense no matter what your contract, right? I mean, so I think part of what complicates it is that it's again, I agree that there are lines, it's just that the lines are not absolutes, right? That the lines are sort of what kinds of things should you be allowed to not face private consequences for, what kinds of things should you not be subject to public consequences for, to governmental consequences, and this is where I think blurring the distinctions actually really undercuts the force of the arguments.
One of the concerns I have as an educator and free speech advocate is not, and this is a basic human rights principle and principle of constitutional law as well, is the concept of proportionality. Sorry, it's not an absolute test. I mean, it's a concept, but people will well disagree about how it applies, and yet it's basic to our Eighth Amendment jurisprudence and to international human rights law. And I just was very concerned and am concerned about employers making categorical statements. For example, we will not hire any student who belonged to any of the 30 student organizations at Harvard that signed a controversial petition. That to me seemed to be very much guilt by association, and I thought it would be a wiser policy and a fairer and more just policy to try to ascertain the specific role of every individual student. I mean, some of them may very well not have known that their organization signed on to this petition and may not have had the opportunity to look at the language before it was issued and so forth.
I have more questions, but I need some sense from you guys. Are you sitting out there with a lot of questions? So if we opened it up now, am I going to get, So questions out there? We can open it up now. Why don't we do that?
There would have been questions from
And
the
we will bring a mic to you just so that you can be heard clearly because this is being videotaped. So thanks, Rick. Thank you. Go ahead.
Hey, yeah, y'all talked a lot about kind of walking that line between how a thing is absolute, but you kind of need to find something absolute. Can you talk about how you navigate that when, I don't know, making policy or legislation, or I guess just kind of remedying this problem?
Anyone want to take that?
I wouldn't know from the legislative perspective, but the way it comes up in courts is that there is, in every situation, a quite specific test that the Supreme Court has devised a series of tests that are applied to ask whether particular speech restrictions are justified. And they are all applied in a very fact-specific way. So here's an example that people have been talking about a lot since January 6th. that government may punish speech that is intentional incitement to imminent violent or lawless action that is likely to actually happen imminently. And that is about as narrow a formulation, I think, as human language is capable of drawing. And yet, in particular factual circumstances, individuals who share the same values can well disagree about whether that standard is satisfied. So I mentioned in Tara's class that at least one federal judge has held that that standard was satisfied by the speech that Donald Trump gave to his supporters on January 6th. But many have made the opposite argument, also just based on examining the same factual scenario and applying that test to it.
Let me, by way of something that might be helpful in thinking about having to navigate these situations, the context, just distinguish different things you might be doing, different frames which you might look at an issue and different kinds of issues you might be looking at. So I'm a philosopher, and the two contexts in which this comes up in philosophy is thinking about political philosophy and thinking about ethics. And there's a third context that comes up, which is thinking about the Constitution and then interpretation of given laws that have been passed, right? So the Constitution, both if you're a legislator passing a law, and then if you're a judge interpreting both the law and the Constitution. So when I think of it from the perspective of a political philosopher, I think about what are our rights here? What are the basic principles that should structure the law of a society, whether or not they structure our law right now? What should they be? How should a speech and other issues be dealt with? What are our rights? And I think of free speech as a right, as a fundamental right that a country ought to protect and respect. And I think ours does better than most, but I'm not thinking about the legal issues there. I'm thinking about the principles that determine what the law should be, and then you could look at different countries and say, how well are their laws coming out? And it's in that situation that I think one can draw absolutes here. A second thing is in ethics. In ethics, I think the relevant principle is justice in your dealing with people. What is a just way to deal with somebody who disagrees with you on a subject? And there I think the considerations involved are that disagreements matter, that people's opinions affect how they act, that somebody could be a good or bad person in part due to what they think, and that can make them better or worse. And so that's something you have to take into consideration. But also that human beings are capable of error. It's difficult to get things right. Part of how you figure things out is by talking things through with people who you disagree with. And people can be very good and valuable on one thing and yet very wrong on something else. And so with all those kind of facts into consideration, when you're dealing with somebody within your rights to deal with them, you have to decide, do I want to hire him or not? Do I want to date her or not? Do I want to, whatever. And that's a very separate thing than thinking about what your rights are. And then if you're somebody who's involved in government or you're advocating for particular laws, you have the framework of your Constitution, you have the laws that are currently on the books, you have the whole history of canons of interpretation of those laws. And I think if you're a moral and honest person in law, you also have some sense of what our rights are, of what the law should be, and then you're thinking about how to navigate both what the law should be, what it is now, what you think it should be, what you should do in that context. And I think that range of considerations is what comes up if you're a legislator, if you're a judge, or if you're somebody doing advocacy law work, for example. You want to be thinking about things. So I think just separating out those buckets of kinds of things you could be thinking about helps to think about what bright lines can be drawn, where can they be drawn, and where they can and can't be drawn, how should you proceed?
Thank you. There's another question up here.
So we've been talking about cancel culture a decent amount, and I think the phrase that I often hear on the opposite side of that I don't think I've heard anybody use is the marketplace of ideas. And I'm curious if you think that's a useful metaphor, and if so, what does it mean for something to win or lose in the marketplace of ideas? And if that's even possible, what should the legal and social consequences be for the marketplace of ideas?
Thank you.
Well, the marketplace of ideas metaphor comes from an early opinion by Justice Oliver Wendell Holmes, in which he said, this is just a paraphrase, it's important that he didn't say that truth is guaranteed to rise to the surface in a marketplace of ideas as opposed to as a result of government censorship. But what he said is that it is, allowing ideas to be subject to challenge in the competition of the marketplace of ideas is more likely to lead to truth than government dictate as to truth or falsity. And I think what's important to recognize the limits of the concept as Holmes initially formulated it. And I think for those of us today who oppose top-down government over-regulation, for example, in terms of disinformation, it's not that we think that the marketplace, unregulated marketplace, is necessarily going to lead to truth and love and everything positive, but that we are more trustful of that process, of the process that Greg described, than we are of some kind of centralized gatekeeping by the government. But that said, I do want to make a point that I'm not sure I had a chance to make here. I speak so much, please forgive me if I already said this, that a lot of speech is appropriately not protected. And when speech, for example, does constitute an intentional incitement or targeted harassment or constitutionally unprotected threat, it should be subject to punishment. What I'm talking about is whether constitutionally protected speech that can well still be harmful. Much speech that is constitutionally protected can definitely cause harm. But is that potential harm greater than the potential harm, I would say actual harm, of giving government the additional power and discretion to say, well, we think, that disinformation might lead to adverse health impacts or might lead to adverse impacts on democracy. So it's sort of like, what's the least bad option here?
Yeah, I'll just say, I think, I agree, I think, with everything Nadine just said. I'll just add that part of why I don't love the marketplace of ideas framing is because I think it is implied in that framing that we are all equal actors in the marketplace. And I think anyone who, markets don't work that way. And so, I think when the marketplace of ideas metaphor is used to say, one voice can cancel, can respond to another voice, can cancel another voice, I think that fails to account for the different market power that different voices have. And I think social media is a live, living experiment in all of that. So, it's not, again, I think, right, it's sort of least worst alternatives, but the problem to me with that framing is that I think it distorts the imbalance that may be a purely privately caused imbalance, but an imbalance nonetheless that I think undermines to some degree what Holmes was trying to say.
So I'm very much in favor of free markets, literal markets, freedom of trade. And I think the issue is actually both parallel and connected literally to the freedom of speech, freedom of ideas, including in these ways. Like, a lot of people criticize markets because some people have more power in the markets than others. Some people have a lot more money. I think differentials in money and the way markets handle them over time is part of the mechanism by which markets work. I think markets are an expression of people's individual rights, and I think they lead to people being best able to achieve their goods, whether they're well-situated or ill-situated over time. I think the same is, and the mechanisms by which that happen include large companies and the economies of scale, and it doesn't assume everybody's sort of equal in the market. I think that's true too in a marketplace of ideas. Part of how a marketplace of ideas works to make truth out, not infallibly, not always, sometimes bad ideas get popular, but in general over time is productive to the truth being discovered. Part of how that works is by certain people developing a lot of power in that market and they becoming gatekeepers, not gatekeepers who could forcibly exclude people, but gatekeepers who are looked at. People go to places like it's like if you're a free market company, right, a company that supports free market policies, that doesn't mean you open a store that sells everything. That means you sell the things you sell based on the decisions you have to do it in the context of a policy where, like, everyone's allowed to do that. what a free market, when people talk about being free speech companies, they tend to think that means everybody should be able to say whatever they want at this company, but that just doesn't make sense. It's part of running a company that it deals with speech in a freedom of speech environment, that you have content policy, you have particular decisions you make on it, just like the same is true with goods. I think there are a lot of analogies between markets and speech that are worth exploiting, and I don't think they've been explored enough in the writings I've seen on this.
Can I raise a different aspect of this issue? The marketplace, or freedom of ideas, freedom of expression, freedom of exchange, suppose you say, yes, it absolutely is better than the alternatives in terms of no guarantee that we'll reach the truth, but it's the best path toward further knowledge discovery. Okay. There seems to be, though, an implicit in that if that's the rationale for freedom of speech, if that is the rationale, implicit in that seems to be, see, there's this great benefit for all of us, which perhaps neglects another aspect of free speech, or whether it be a competing rationale or a complementary rationale, one that says whether or not what you have to say is of any use to anybody or not. You have a right to say it as long as you're not harassing her, libeling her, infringing on others' rights and those rights. Any observations from any of you?
I would definitely say they're complementary, and more importantly, that's what I understand the Supreme Court to have said. The pioneering free speech opinions came from Holmes and Brandeis in the early 20th century, and one of Brandeis's great opinions, and I'm so sorry, paraphrase can't do justice to the language, he basically was saying freedom of speech has both an intrinsic value and an instrumental value, that it not only is the greatest engine toward liberty and democracy, but it's also essential for individual self-knowledge and self-actualization. More recently, in a case that came out of the Vietnam War era, where the Supreme Court upheld the right to use the phrase "fuck the draft" in a courthouse. And that, by the way, I always have to explain to students today, you cannot imagine how shocking and how taboo that word was then. Now it's in everyday parlance, but it was so shocking. And you really, to understand the importance of the Supreme Court's decision, it's really important to understand that. The Supreme Court said that in that case that it doesn't matter if that speech is communicating to anybody else, that speech also has a really important function of allowing the individual to express not only ideas that are articulable, but also inarticulate emotions and feelings, and that may be the force of this particular epithet, rather than a more reasoned statement. I think the draft is,
that helped us understand something better.
Because the point is that speech is not about truth; it's about liberty, right? And part of being part of liberty is the right to be wrong, right? And I just think that this is again part of why I resist the marketplace analogy, because markets, I think, are designed or at least intended to be efficient, and I think speech is not. And ought not to be, right? Otherwise we're missing the point of it.
With both economic liberty, markets, freedom of the market, and with intellectual liberty or social liberty, political liberty, whatever one you put free speech under, with any kind of liberty, there have always been two kinds of justifications for it. And one is a kind of collectivist utilitarian justification of it. The social good, the overall well-being will be better off if we have it. That kind of justification of markets is how people justify them with efficient markets. There's always been another kind of strand of justification of them. I think it's the one that you find in Locke, it's the one you find in the American founding, which is that, no, we have an individual right to this. It's an individualistic a basis for these kinds of freedoms. Disagreements about which freedoms they are, but the freedoms are not here because they serve some greater social good. Rather, they're here because individuals have an inalienable right to them. We can think about where that comes from and how that works, but there's something about individuals' nature that makes it right that they should be free in this way. And my own view is that that's the proper justification of freedom. but it's precisely because of those facts about nature that mean that we should have them regardless of any particular social consequences. Those facts explain why they do have the good social consequences that they do.
More questions out there?
You know, for dinner.
It sounded really intriguing, but there's one stuff behind you.
Thank you guys very much for the discussion so far. So this conversation has been pretty abstract so far, but I think one concrete might kind of highlight the philosophical differences between you guys. And so I would assume all of the panelists would agree that I can be free to invite anyone or disinvite anyone from my house. And this would be characterized as a freedom of expression. But if a private business owner, or if you're somebody that endorses discrimination laws, wouldn't it follow that a private business owner somehow has less of a right to freedom of expression than I do? And if so, what would be the justification for him losing this right?
So I think the answer is yes. And I think part of the rationale for that is that a private business owner has less domain over their business than they do over their home. And that this is true not for all private. I mean, if I run, if I were some sort of woodworker and ran a woodworking business out of my home, maybe that would be different. But the difference for most businesses is that businesses are operating under licenses from the state. And that the state, usually as a condition of giving you a license to do business, imposes some conditions upon the means by which you carry out your business, versus no state is licensing how you carry out your personal activities in your home. And so, I think what separates out the sort of the person from the business owner is the private person in their personal capacity does not depend upon the state and is not regulated by the state in how they go about their personal business. Many, not all, but many businesses are, and to my mind ought to be.
But again, I have to say that it depends, and the devil is in the details, and the fact that government definitely has more power to regulate expression in a business context does not mean, and I know you're not saying this, Steve, but I think it's really important to point out, that certain regulations of businesses can be and have been successfully challenged as violating freedom of speech.
Right. So imagine, right? I mean, imagine that. The state of Texas regulates cosmetologists, right? Mm-hmm. People who are doing like personal care, right? And so saying that you can't represent yourself as having been, I don't know. So assume one condition is you have to post your license in your place of business, right? That doesn't seem to be running afoul of anything, right? You have to actually have a license, right? You actually have to have been certified to be skilled in this behavior, and you can't misrepresent yourself, right, as having a license. Okay. Now if the state says, oh, and you can't wear any political clothing while you're cutting hair or while you're doing nails, right? Like, I mean, again, this is the point. But those, with the difference between the private person in their home and the business owner is that the business owner is providing at least some outward-facing services to the public. That's the point at which the government's ability to impose some constraints on the business owner, I think, kicks in.
And
this is one of these issues where are we talking about this from the perspective of current law, or are we talking about it from the perspective of rights and what we think the law should be? Because there's not much debate over the fact that the current law treats businesses different than private individuals, and it's not just the current law. I mean, the main law that you're referring to it's a provision of the Civil Rights Act of '64 that you can't discriminate in private business, but it didn't start with there. There was issues about public accommodations dating back to the founding era, but but I think, well, anyway, going back at least then. So but the '64 Act much expanded it, right? So one question is, are those laws right? And I think they're not. But that's a separate question than what is it within the current standard of current treatment. And whether they're right or not, what is the relationship to the right of free speech? And I think there's a kind of underlying unity to our rights, and that there's a kind of artificial separation in American law between speech rights and more generally what are seen as personal liberty rights and economic rights. This brings me to something I wanted to suggest as, I can't prove this, but as a possibility to consider. You talked a lot before about the kind of very censorious attitude and self-censoring that people have in what are private concerns, private businesses, private schools, and so forth. But one thing that we should think about too is that these, companies, for example, are operating in an environment where there are a lot of civil rights law and liabilities. For example, what's considered a hostile work environment and what might make something a hostile work environment. And so cultural institutions are, and cultural mores about what things are considered offensive and what businesses have what policies banning what kinds of relationships and speech are all coming about in the context of certain ways, a certain civil rights law regime. And there are questions as to whether that civil rights law regime is right or not, whether it was the right way to end segregation, which was, of course, a great evil, and on many details, whether it's right or wrong. And if it turns out that some of the cultural mores that are happening there, some of the things that we're thinking of as creating social pressure to conform, are actually created because of fear of lawsuits, which lawsuits are possible on laws that it might turn out violate free speech rights to begin with, and I think they do, then it's not just the issue is, does the government ban new things or does it not? It might be that it's doing things that are constraining people's free speech now, in part by creating certain social conditions that are obvious. And there have been people who have tried to document this. There's a recent book out on this by someone who I feel a little bad about mentioning because he turns out to be a racist, and I think not repentant enough one. But nevertheless, there was some good material in the book. Richard Hanania wrote a book on civil rights law as the origin of woke, and I think there's some interesting observations there about the causality. And I'm not sure if they're all right, but I think it's a thought-provoking issue.
Let me ask something that's, again, related, I think, to this question as well as something else I wanted to raise. So, just the private party, forget the business for a second, right? Also, it seems a matter of freedom of association, another First Amendment, right? It's not
Yes,
just
exactly.
speech, not just
Exactly.
expression. And we've seen these cases in recent years, often religiously inspired by people who don't want, for instance, I don't want to sell a cake to the gay couple, right? But there are anti-discrimination laws that say you can't discriminate in who you do business with, right? We had 303 Creative just this past semester. They ought to call it a semester, it's a term, whatever it was, I'm not too academic-centric. So you have religious expression, or you have religious freedom, speech freedom. Is it compelled speech? I have to make your state is forcing me to say something in the kind of work that I do that I don't want to say. You've got religion, you've got association, you've got speech all coming together. A related question, I guess, somewhat related, I think. In your work over the years, Nadine, I think you've often emphasized the importance of the difference between speech and conduct, or speech and action, right? I mean, one of your very early articles, I thought, put it really powerfully, and then I've seen the theme, again, to differing extent, you play it up or don't play it up, but that there's a really important difference between speech, on the one hand, we need complete freedom of speech, freedom from the law, and action or conduct. I'm interested in you guys, how important do you think that distinction is? How might it relate to some of these, again, some of the recent cases involving religious freedom or speech freedom vis-a-vis anti-discrimination?
May I say something about that, Tara? Part of the reason why I was kind of frowning when you, hello?
Is it
I think
green?
it's-
We've cut them.
Oh, your
I
mic.
think I used
be
up the
dead.
battery by talking too much. Thank you so much. I was kind of frowning because I don't see that as a meaningful distinction. I'm sorry if I didn't make that clear, because I think that we can describe just about everything as expressive conduct. Everything we do can connote some message. And there's some, even now I'm waving my hands around. And so in terms of the free speech, and this is the way the Supreme Court sensibly has looked at it, the free speech analysis is the government regulating the speech aspect? Is it specifically singling out the message, or is it singling out the conduct? So suppose the government punishes somebody for burning a flag, not because they care about the flag being burned, but there's a general law that says you're not allowed to have a fire on this street at this time. And we don't care if you're burning a bra or a book or a flag or leaves. And
Qua speech
yes,
or qua
exactly,
action? Yeah, yeah, yeah.
exactly.
No, I want to make,
Yeah.
I don't think I've misunderstood you.
Yeah.
But, I mean, for instance, the powerful example that I thought you gave in a law review article many years ago is something like this. Lynching a person sends a message.
Yeah.
It expresses a viewpoint. We don't think, well, it expresses a viewpoint, therefore it gets First Amendment protection. So that's the kind of
Yeah,
thing
and again, it's the fact that it conveys a message is not sufficient for it to be protected. It may be, we can assume for the sake of argument, subject to First Amendment review, but the question the Supreme Court would ask is punishing this expressive conduct justified by compelling government purpose, and is punished? So assassinating a president certainly conveys a message. Even if we said, well, it raises a free speech issue, it would still be constitutional because, you know, punishing this particular type of expressive conduct is necessary in order to protect human life as well as democratic stability.
I probably didn't
Yeah.
put it well, but in terms
Yeah.
of your thinking is that the law, it's really important that the law distinguish in how it treats these things, speech and conduct on the basis, or I'm still not putting it well,
I
guess.
don't think so, and I'm so sorry. I have a long answer to this question in the book, but basically, the fact that something conveys a message is not enough, no matter what format the message
Right.
is, whether it's a
Yeah.
demonstration or a lynching or waving your hands around. It's not, speech is not absolutely protected. Expressive conduct is not absolutely protected. And the examples of conduct that you give, whether they express a message or not, they would still survive First Amendment scrutiny because freedom of speech is not absolute. If the restriction is necessary to promote a countervailing goal of compelling importance and protecting human life certainly satisfies that goal, then that expressive conduct could be restricted.
Did you guys want to comment on this at all? Or?
I could say something about it.
Yeah,
I think we're going to pass these around. So again, here's the question of sort of what is the state of the law and jurisprudence on the First Amendment, and what is the, you know, what should the law be, or what's the moral situation? So I just want to speak from the second point of view, what I think the nature of the moral rights are here, that however well they're embodied in our current law. So one way of thinking about it is, if something is such that it ought to be illegal in the first place, that you don't have a right to do it in the first place, the mere fact that you also send a message by doing it shouldn't then make it within your rights. However, if all our rights were equally well protected under the law, I think that would be a sufficient way to deal with this issue. You would say that because something is expressive content, conduct, it doesn't get any, because conduct is expressive, it doesn't get any extra protection that it wouldn't have had if it wasn't expressive, when it is, you know, rightly made illegal because it violates other rights. But I think the issue with American law now is there are all kinds of things that I think are within our rights that are violated all the time by law. And one way that you're supposed to be able to get out of that being violated as well, but I'm speaking here. And so that the fact that it's expressive is seen as a thumb on the scale for it being something you should have a right to do even when you're otherwise not. And you can see this when we were talking about the business cases. Like, there's a whole line of litigation now being undertaken by IJ, advocacy litigation, trying to get various business regulations overturned, licensing including in some things, on the grounds that, well, there's expression involved here, and this regulates expression. If you say someone can't be a dietitian unless they're licensed
Or a
something.
psychologist,
Or a psychologist,
right,
right. So the fact that, my take on this is the fact that free speech is better protected in America than other rights leads to a kind of reasonable legal strategy of
Free speech opportunism, I've heard.
yeah, of trying to put things that are expressive under its heading. And I think it's a good legal strategy now, but I think the ultimate way to think about it is something within your rights in the first place? If it wouldn't be within your rights in the first place, but now you're saying something while you're doing it or by doing it, that doesn't make it within your rights if it otherwise wouldn't be. That's how I think of it morally.
One
we
more
can
question
just
from the floor.
lean
Yes. The mic is coming to you. There you go. Thanks.
Thanks, and thanks for this discussion. Professor Salmieri, I appreciate that you have drawn the distinction between constitutionally protected speech and speech that makes people uncomfortable. And it seems like, for all the last 5 minutes of discussion, there's fairly settled jurisprudence on what's constitutionally protected. We may have to confront some things about what an incitement to insurrection looks like. I think there is much less discussion, and during all the things I attended during Free Speech Week on campus, much less discussion about the boundaries of what ought to be acceptable in civil discourse, which is what we're mostly talking about when UT gets ranked, in the bottom 10 in the country in the fire rankings. We're talking about what it's okay to say that wants to have a healthy and vigorous debate, but probably not offend people. And the voice inside my head that tells me that might be offensive to people is mostly a salutary influence on my behavior. But in the panel, Tara, that you hosted during Free Speech Week, the guy from, I don't know where he was from, but who made the point, look, you could get killed for suggesting that the earth revolves around the sun, not vice versa. You took a big risk supporting the theory of evolution a couple hundred years ago. Somehow this discussion, in my view, needs to get to the question of, what it's okay to debate about and what it's not okay to debate about, or what it's okay if people don't like what you have to say. And it's not necessarily something that ought to be, that the University of Texas ought to be at the bottom of the rankings for if you're saying something that the general population here finds offensive. I'm just curious, especially I'd like to hear from Ms. Strossen about this, because I've really been studying the fire rankings and talking to folks from fire about it, and I just feel like that's the next step of the analysis that I don't feel like they've engaged with yet.
Yeah, thank you so much, and thank you for, I didn't do my homework, but the UT is the bottom 10, I gather from what you say. Well, you're in good company with Harvard and some, the most prestigious schools tend to be at the bottom, so there's a positive side and a negative side. This is a really, really important issue, especially for those of us in education who are trying to instill appropriate values in our students to create the culture. There's been a lot of talk on the part of FIRE and other free speech advocates that we ought to encourage orientation sessions about free speech, not only the law, but try to inculcate some norms, some habits, some approaches toward discourse. And I agree with a point I think that Greg was making at the beginning, and Stephen as well, that you have to be willing to face the consequences to some extent of what you say. I completely agree with that. I would wish that the consequences would not be unduly harsh, but I think we also want to inculcate habits of courage and willingness to face some adverse consequences, being unpopular because of what we say, if there is a really important reason for saying it, namely that it's consistent with your values and with your research and with your analysis. And I think the only way that this can be approached is very concretely and experientially through setting up opportunities and modeling for people bringing together faculty members and other experts who disagree with each other and then model a civil but respectful discussion. I've heard students respond very positively to that, especially to see people who very strongly disagree on issues that are very important to them, nevertheless engaging in a respectful dialogue and also showing that they, as is inevitably the case in my experience, inevitably are going to strongly agree on some issues that are really important to them, to try to get people beyond this, what seems to be a pervasive framework that, you know, you're either a good guy or a bad guy, you know, and it's not just that you have an idea that's bad, but that makes you into an evil person, period. If we can get over that kind of, you know, just rigid oversimplification of who a person is and find ways to get to know each other in a more full-fledged way, above and beyond disagreements about particular issues.
Can I just say, I mean, we've been so agreeable, and I feel unfortunate ending on a disagreeable note, but
No,
I
good.
rather
Please do.
strongly,
Please do.
I rather strongly disagree with the sort of the view that we can solve this from within, and wholly from within, because, you know, not that long ago, the faculty council at this university adopted a very, I think, courageous statement supporting particular types of efforts toward increased diversity, equity, and inclusion. And the response was to provoke the lieutenant governor and the state legislature into banning us from doing the things that we had publicly supported through speech. So, you know, as faculty members at a university where that happens, I don't know that the response is, let's make sure that we're hearing our fellow faculty colleagues better. I think the response to that move is, well, shoot, we better not stick our necks out again. That's not because of anything the university did, that's because of something the state legislature did. And so, right, and so if we're gonna have a conversation about how to improve our fire ranking, it seems like we should be talking about some of the reasons why it actually is sometimes not necessarily to the advantage of students and faculty at this university to take courageous public positions, and it has nothing to do with this university and a lot to do with how the university is targeted by the political leadership of our state.
We are essentially, I mean, we're out of time, we're over time, so I wanted to give you all, but I'm no longer going to do it because we're over time. But Greg, did you
Could I
want to
say
get in
something
something
just
on
on
this
this? And this-
or broaden as well?
On this topic, I think all three of our statements on this are a good closing issue anyway. So a lot is raised by this question. So first of all, we're a public university. Our being a public university means that we're, you know, under the domain of our state legislature and so forth. I think the whole existence of public education is ultimately incompatible with the ideal of free speech, and so I think all universities should be private. But here we are, we have a public university. Even private universities are, but that puts us in these kind of conflicts, right? Even private universities are overwhelmingly funded by public money in different ways, and that's created a mindset that I think is really toxic to thinking about speech in education and to thinking about things like admissions policies in education, where the nation's body of universities is sort of seen as a public resource that we as a polity should think about how should they function. What should their admissions policies be? Should they be race neutral or race disparate? What should their speech policies be? Rather than thinking of each of these as different institutions with different demographics they're serving, different particular missions, and having different policies regarding speech to do with the different things that they're on about. And I think a culture of free speech in a society at large involves people really accepting that there will be lots of different institutions with lots of different speech policies in it. There will be, you know, a group of people who are all believers in a particular thing, and they all go to discuss that thing, and dissent from that isn't welcome there. And those same people may well be members of another debating society, and wider debating societies, or different groups that have different inclusion criteria where different ideas are and are not welcome. A flourishing society has all kinds of different organizations like that, and a flourishing intellectual life for an individual involves belonging to some groups that are advocacy groups where you're agreeing with things. Right. So I think there is an important place in a society for a kind of organization where the maximal difference of ideas gets expressed. And I think in a society like ours, universities are a good candidate for that, where it's tolerated on campus to have people saying things that other people on campus regard as evil. But in order to have situations like that, I think some ideas might make you a bad person. But then, if so, we still need, I think, in society to have some institutions where people who regard one another as bad can function. But if we're going to have that, we have to have those institutions set up with rules where the two people both participating in it don't amount to each thinking the other is a good person. And that's not, it's like this is a special place where we come to debate the things that are most weighty to us. And I think that's only possible, again, in a society where you allow for a wide range of different speech policies in different organizations. And so the very idea that there's one way that a workplace or a business or a school should be with respect to what ideas are tolerated and what things are discussed, I think is actually counter to the idea of free speech into a society that respects it. I think we need that kind of diversity.
Okay, let me wrap us up. So if our general question to begin with was what's at stake in the free speech debates, clearly we have a lot more to figure out on a lot of fronts that we need free speech to help us or enable us to do. Thank you guys all very much for coming and for your serious attention this afternoon, and thank you very much for your time.